and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, August 13th, 2024. Today we have a tale of qualified immunity from the Eighth Circuit, and then we have some really interesting Fourth Amendment geofence warrants Google accounts stuff from the Fifth Circuit. The Eighth Circuit one, I think, will infuriate some of the listeners, and the Fifth Circuit one may hearten your hearts. And so, maybe we'll come out on balance. With me today is someone who is extremely balanced, and that is my good colleague at IJ, Kirby Thomas West. So, Kirby, welcome back to Short Circuit.
Thank you so much for having me.
So, Kirby, we have done many episodes over the years on qualified immunity, this doctrine that lets government officials get away with violating the Constitution even when they admittedly have violated the Constitution. Here, though, it seems like they didn't even want to get qualified immunity, or their lawyers didn't, and then the judge said, "Oh, no, you will," and they ended up winning because of that, and I guess that's perfectly okay. So, for some listeners, this may seem, who aren't lawyers, this may seem like, oh, maybe it's not that big a deal. But for those of us who have actually, practiced in trial, I gotta say it's quite infuriating. But I'll get your take on it too.
I am similarly infuriated. So, this is a case out of the Eighth Circuit. It's a very brief 3-page opinion, and we have a former inmate in Missouri who had sued prison officials for alleged violations of the Eighth Amendment. Now, we don't even know at all what the substance of the allegations are here. There's no, factual recounting, or really, we don't know what the underlying claims are. What we do know is that he had brought these claims against the prison officials, including for failure to protect him from sexual abuse and for retaliation in reporting the alleged abuse against him. And the district court here had granted summary judgment for the prison officials who had been sued, granting them qualified immunity. But as you note, in a very unusual way. So we talk about qualified immunity a lot. I know you talk about it a lot on this podcast. But I don't even think actually that the award of this is the substance of the legal decision to give them qualified immunity is what's interesting here. What's interesting is more the process by which the court came to grant these officials qualified immunity. So, initially, when this case was filed and the government filed an answer, which is the response that a defendant gives to a complaint, they did list qualified immunity as something that they intended to raise as an affirmative defense. But after that, the court said, okay, if you want to raise qualified immunity, you have to file a motion explaining the basis, the grounds for qualified immunity here. And then the government changed their minds and they said essentially, no, actually, we don't see grounds to assert qualified immunity, and we're going to choose to litigate this case another way. We're going to argue that there was actually no constitutional violation here, but we are not going to file this motion that the court instructed us to file, alleging the basis for the qualified immunity. The case progressed to trial, went through discovery, progressed to trial 4 days before the trial was set. Separately, having had a judge cancel a trial on me a week before trial, just extremely infuriating for a judge to do this 4 days before a trial.
Happened to
But
me as well. Yep.
any litigator, I think, can relate to the frustration of
Mm-hmm.
having that run up to trial and then just getting the rug pulled out from under your feet. But 4 days before the trial, the court said, I really think this qualified immunity was a thing that you guys should have been talking about. And I know I told you to file this motion a while back and you said you didn't think qualified immunity was a thing, whatever. But I really think qualified immunity is a thing. So I'm going to specifically instruct the parties to brief this issue of qualified immunity, and I'm going to decide this before we get to the whole hassle of a trial. And surprise, surprise, the judge found, oh, yes, I was right. Qualified immunity is a thing here. And I am going to award qualified immunity to the defendants and grant summary judgment for them in this case. Now, on appeal to the Eighth Circuit, the plaintiff, challenged this and said he thought it was improper for the trial court to have required essentially the officials to file this motion addressing qualified immunity. And the Eighth Circuit disagreed and affirmed the motion for summary judgment. But I thought it was so strange, their rationale. They really never actually addressed the substance of, was it proper for the district court to go out of its way and say, I think actually you might be litigating this case wrong, and you should actually focus on, this defense rather than this defense. The Eighth Circuit just said, it satisfies judicial efficiency for the judge to decide this matter of law, this question of law, that is, are the officials entitled to qualified immunity here, before a jury gets to any decisions of fact. And it would be kind of complicated to have these parallel issues at trial where the jury is worried about um, any factual disputes, and the judge is simultaneously considering the issues of qualified immunity. It might be complicated, and it serves judicial efficiency to break these into two pieces, and to let the judge decide the issue of qualified immunity first. But that wasn't the question in the case, right? The question wasn't, can a judge split it up and handle the legal issue first and then the factual issue? The question was, is it appropriate for a judge to go out of his way to instruct the parties how to litigate the case? And this is, totally contrary to the principle of party presentation. That is, generally in our legal system, the parties decide how they're going to litigate the case, and they tee up the issues, and present them to the court, and then the court decides the issues before it. So truly just a kind of baffling decision from the Eighth Circuit to not even address that this was an unusual way for the district court to have decided this case.
And then, I mean, there's so much we could say about this as litigators, but uh, it's then infuriating how you don't even learn about the facts of what was qualified. And it seems like the court says that the only question on appeal was whether the court should have asked for qualified immunity, and so they don't actually challenge the substance of the qualified immunity ruling, which I find hard. I haven't read the briefs. I find hard to believe that. I mean, maybe counsel just blew it and didn't argue qualified immunity, or the facts are just so bad. I mean, there's a lot of questions here about the facts. Like, if the facts are so bad, why didn't they move for qualified immunity at a motion to dismiss stage, right?
Right. And I think just the contrast too of how the court is treating the parties here, on the one hand, help giving, just totally on the side of the government, giving them instructions about how best to defend the case. And then on the other hand, you have the court talking about the lack of competent evidence to support a finding of retaliation. And they
Yeah.
talk about there how the plaintiff had submitted a declaration, but it wasn't signed under penalty of perjury, so it's not properly considered. It's like these procedural defects with the plaintiff's case, that they're going to hold him to every single detail of kind of crossing his t's and dotting his i's. But then when it comes to the other party in the case, the government actually has the court telling them, oh, maybe you should actually do it this way, let me give you a hand here.
And I could see a lot of reasons why that happened. I mean, I'm just speculating, but I'm guessing because they were all prepared to go to trial, and then all of a sudden it's no, we're going to do qualified immunity summary judgment. They didn't have their ducks in a row, and they overlooked having the penalty of perjury statement on the declaration, and that's why that got in there. We also don't know why there's only a First Amendment claim at this stage, and there was this, I think it was Eighth Amendment claim you said earlier.
Yeah.
So maybe the facts weren't great, it turned out. But the funny thing is about this whole case is the government doesn't ask for a qualified immunity briefing earlier in the case, which you almost always see in these cases. And so that kind of makes me think they really thought there was a question of fact and they wanted to go to the jury, which is how the system's supposed to work, Seventh Amendment and all that. And then if it had gone to a jury, you can have qualified immunity at the jury stage, but the court's right. It is a little bit awkward at that point. It wasn't really made up by judges for the jury stage, and so the court's right that it maybe it's not going to work at that stage, but that's the party's decision. And we see
Yeah.
this over and over again. Like, I know we at IJ have been involved with other issues where the court will sua sponte ask for an issue to be addressed. Like, one is younger abstention, which we don't need to get into right now, but we've talked about it on Short Circuit before, and it's where a federal court can't get involved because there's state court proceedings on the same issue. and courts sometimes just on their own decide younger issues. Here, I mean, I have to say, here at least the court didn't like sua sponte on its own decide qualified immunity. It did at least ask for briefing, and it is a hazy line, like when a judge could just, at a pretrial conference go like, "You're really not moving on that issue? Are you sure you don't want to move on the issue?" Like, I've seen that in cases. I don't think that's improper. But here, it seems like it was really a strategic decision not to do qualified immunity, and the court does it. And I got to say, I'm guessing the court did it because it thought, oh, then I don't have to do this huge trial. I can just get rid of this case on the papers, and I don't know. I'm going on vacation soon, so I'd rather have that
Yeah.
off my docket.
I think that's exactly right. And I think it was really interesting, the great John Ross, who puts together our short circuit newsletter every Friday, which everybody should subscribe to, put this case in conversation with a case from the Supreme Court from 2020, talking about just kind of truly insane behavior by the Ninth Circuit, in which a criminal case had been tried and it had been appealed to the Ninth Circuit, and oral argument heard and everything. And the Ninth Circuit essentially said, we don't really like how they framed this case. We think that the criminal defendant should have argued that this whole statute is facially unconstitutional under the First Amendment. It's a very interesting case. But the Ninth Circuit had then appointed amici to address three different issues, and then reheard oral argument where essentially the amici were the main parties, and the criminal defendant was kind of off to the side just saying like, yeah, what they said, I guess. And the Supreme Court there said, this is just not the way that we do the judicial process in the United States. And Justice Ginsburg there has this kind of really interesting opinion, and so I think this is kind of one of her close to her last decisions from the court. But she talks about how courts are essentially courts are essentially passive instruments of government. They do not or should not sally forth each day looking for wrongs to right. They wait for cases to come to them, and when cases arise, courts normally decide only questions presented by the parties. Now, I know, Anthony, it might make you a little nervous to hear courts referred to as passive instruments, or anything like that. But I know this isn't this what the Eighth Circuit did here is not what you mean when you say to judges to get engaged, right? And I wonder, I
Right.
think I know you're the host of this podcast, but I do think it might be interesting to hear what you think about the difference between judicial engagement and then this kind of um judicial involvement in a case, to the extent where really it looks like the judge is more kind of taking sides.
Yeah. I mean, there's two things going on there. One is judicial engagement, which we always talk about judges not being afraid to hold the government's feet to the fire and interpret the Constitution without over deference to what the government wants to do. So that's judicial engagement. But then there's also the principle that in this country, we have judges respond to the parties. We have cases or controversies. And I think that value of only having judges respond to cases brought before them can be overplayed in some ways and kind of drift into, overly over broad calls for judicial restraint. But generally, it's a good thing that judges decide what the parties bring to them, right? We don't have judges just throwing opinions all over the place. And so when you have a judge involving itself, whether it's, say, pro plaintiff or pro defendant, pro government, pro whatever, pro prosecutor, that doesn't make for great judging, because it's not the issues that the parties are bringing to it. It's the issues that the judge is putting together. And then you're going to have you're more likely to have judicial bias, I would say, in that case. And this is, this is a gray area, as I said. Like, this isn't the most egregious example, but given the timing and the eve of trial and how the parties had set themselves up for everything, it seems like this is an instance of a judge being what our friend Clark Neely says, Article 3 co-counsel for the government. And I think that's what happened in that Ninth Circuit case. I remember that and thinking, I remember liking the result in that case, but thinking this is a little weird that the court went out of its way to appoint people to argue when the defendant, had nothing to do with that in the first place. So there needs to be some understanding that you just kind of let things play out. I think that the same might be true even if it was if it was a pro plaintiff situation here, where they're saying, you sure you want to make this argument, and then I'll rule for you. I don't think courts should be doing that. But again, this is not a fine line. But it feels wrong what happened in this situation.
It does. I think
So,
you're right too that the timing makes a big difference for me. That it's right. The case had progressed so far, and it wasn't like you said a
right.
casual thing at a scheduling conference or something like that. Like it really felt like the court going out of its way to redirect the direction that the litigation was going in.
Yeah. And it wasn't just like, are you sure? It was the court basically ordering them to do summary judgment qualified immunity briefing, and then delaying the trial. And the other thing that, judges, like you were talking about the trial canceled, it seems like some judges just don't think of the human toll when it has to do with scheduling like this, and all the hours that both sides put into preparing for trial. And then 4 days before, it's not like there was a family emergency or something. They're just, well, I think it would be better for me, the judge, to litigate it this way. And so
Yes.
who cares about all
Yes.
those hours that you put into trial prep?
Right. And for non-lawyer listeners, like getting ready for trial is just a truly colossal undertaking. And it like you said, it involves countless hours by the lawyers, the paralegals, like getting your client ready, having meetings with your client to prepare them to be cross-examined, and I mean, it's just such a colossal undertaking, and to have all of that kind of go to waste yeah, it is. I think disrespectful to the parties for judges to do things like that.
Well, in the Fifth Circuit, we do not have the problem of the court going out of its way to rule for the government, because the government, well, it kind of wins, but it kind of loses. It's a mixed bag for the actual defendant, the actual parties in the case. The defendant, in fact, doesn't win in the end. But along the way, there's some very interesting constitutional issues that the government, I'm sure, is not happy about, even though it actually won this appeal. So this case is United States versus Smith. It has to do with a heist by three gentlemen. They were eventually apprehended because of something called a geofence warrant. And because of this case now in the First Circuit, or the Fifth Circuit, geofence warrants are unconstitutional. That is a big deal for law enforcement in the Fifth Circuit. Now, it splits. This just came out on August 9th, and it splits with a ruling of the Fourth Circuit that just came out last month that went the other way on the biggest issue here, which is whether this is a search. And what we're talking about here is essentially your Google account information, your geolocation data in your Google account. So we'll get into this, what a geofence warrant is, what Judge Ho in the Fifth Circuit, sorry, Judge King, Judge Ho was on the panel in the Fifth Circuit, said. But I want to give a disclaimer up front that some of this is technical stuff, like how your Google account works, how they do the searches. I am not an expert on that stuff. I mean, I have a smartphone. That's about it. And so I may get some of the details wrong. Some of you techies, listening may be shouting while I'm speaking that I'm getting this stuff wrong. But I think 30,000 foot level, I'm basically in the ballpark, and I think most of you listening will understand what I'm talking about anyway. So we'll start with just the actual facts. So there was a mail carrier who was driving his route in Mississippi. It wasn't actually delivering mail. It was picking up stuff from different post offices and then kind of bringing it together. And one of the things that he was picking up was bags of cash. So this is like cash, that post office gets from selling stamps and all that. They got to do something with it. And so how the these post offices did it is someone picks it up and brings it to another location. So these robbers, I think, knew what was going on. They had cased the joint, and so this truck pulls up. The driver's sitting there. He's about to get out and take the stuff out of the truck or get a delivery, and they basically say your money or your life. And so he sees one assailant. They take the stuff in the back. They get away, and it turns out there's actually 3 of them involved. He then drives to the man who was robbed, drives to the front, alerts post office folks about what happened, and that's it. There's one witness who's across the street who lives there, who gave a description of what he saw, and basically he saw this one car that seemed kind of suspicious before. He didn't think so much of it, but he seemed kind of like it was casing the joint beforehand. And there was one man, there were a couple figures, and one man seemed to be on a cell phone. And then also at one point kind of was looking down at, probably a smartphone. Putting all that together, they can tell that, which is not, unusual these days, that these people seem to have smartphones on them. Okay. So months go by and they get no leads. They can't find who these robbers were. And so then someone in the department says, "Hey, have you heard about Geofence Warrants?" Now, this happened in early 2018, the robbery. The first Geofence warrant was only made in 2016. So this is a pretty new thing. But I got some stats from this case and from the Fourth Circuit case that talks about the similar trajectory of how this has happened. So the first Geofence warrant was only in 2016, but by 2020, there were over 11,000 that Google itself received. And by 2021, 25% of all of Google's warrant requests were these Geofence warrants that I'll describe what they are in a moment. So, Google gets all kinds of requests that are warrant requests that are just normal law enforcement, right? So you have a suspect, his Gmail account, and you want to know, okay, well, what's in his emails? Is there incriminating evidence in there? We have probable cause. That's all normal law enforcement stuff. But out of all that, 25% is this kind of new wild Geofence warrants. So what is a Geofence warrant? Well, Google started getting these 2016, basically wanting to know who was in a location at a specific time when law enforcement doesn't know who it is they're looking for. They just know something bad happened there, and so who was in the location. So Google, it seems like there was kind of a push and shove of how to deal with these, and they came up with this system that has 3 steps. So the first step is law enforcement comes and says, okay, so for example, in this case, the robbery was sometime after 5 and before 6 p.m. on this date, and it was, in this area. So the warrant says we want everyone who was in this area, and it was 98,000 square meters, which I did some back of the envelope math, and it's not that huge an area, but it's a number of football fields, basically, size. And so, if that's the middle of a city, that could be hundreds and hundreds of people. If it's in this area, it was less, but still, it's a fairly large area, all things considered. So they say at that time, and that area, and then there's some spillover, I guess, even outside the area of what they request. And then Google takes that request, but they don't have like a big chart of where everyone was at every time and say, oh, okay, it's like these 50 people will give you their data. They have to search every single Google account that has location history. Now you can opt out of location history, and Google is now changing things so it's like much more private, and I think it stores on your device instead of on the cloud, and you can opt out of it easier. But like I looked into it once, it's really hard to figure out how to opt out of your location. Have you tried, Kirby, of like how this works?
I haven't tried, but reading the decision, I was like, "Oh yeah, this is beyond me." It's not something I would have thought of. My tech expertise also kind of comes down to smartphone ownership, so I'm right there with you, Anthony.
Yeah, I mean, I remember talking to a colleague of ours at IJ a couple years ago who's much more savvy about this stuff. About like he said, "Oh yeah, you do this, 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 and then they can't track you." And I was like, "I have no idea how to do that." So I guess a lot of people do opt out, maybe accidentally, maybe not. But all told, of people who have like this full history, there are 592 million accounts. So obviously that's worldwide because so many people use Google in some way. Even if you have an Apple phone, you're probably using Google in some way through some apps. So it's enormous amount of people. So Google has to take this request, right, that within this hour and this small location, but they have to search all 592 million accounts. Then they get that data back and say, okay, well, here are the people who were kind of in the area. Then this is like step 2. Then law enforcement says, well, of those, we think, some are like, we're only there for a few seconds. Maybe that's someone driving through. Okay, we want these look more likely. And then they can get the actual identities of these people and then, go about your law enforcement work after that. So they did all this and they caught these guys and they're tried, found guilty, and now they're appealing, saying that the warrant was unconstitutional and the evidence should be thrown out. So the question here really revolves around the application of this case from a few years ago that we've talked about short circuit before, called Carpenter. So this was the case, some people, you may remember, 2018, where there's a bank robber and they're only able to find him by using cell phone data. So most people don't know this, but your cell phone has a ping on different towers. And so if you put together the pings and where someone was, so they're at this bank at this day and this bank that day, you can get together where they were. And the court said, even though that's held by the cell phone company, not by the individual, the defendant, we're going to say the third party doctrine, which usually would mean you can't challenge that kind of data because it's in someone else's hands, doesn't apply, right? Cell phones are almost required these days. And so, and so we're going to say, the world has moved on. And so when we look at whether there's a reasonable expectation of privacy, you can challenge that, which is the next step in the Fourth Amendment analysis. So the question is, does Google data apply like cell phone data? The Fourth Circuit last month said no. It's just different. You can opt out of it. It's not as big a deal. And Judge King is like, come on. It's really hard to figure out how to opt out of this. It's something almost everyone has. Almost everyone has a smartphone. If you have a smartphone, you're going to face this conundrum about your Google data or whatever the app is, but Google is by far the one that most people have. And so we're going to say it applies. So then the next step is, okay, does the warrant conform to the Fourth Amendment? So Fourth Amendment says you need to, if you have a search, which now we're past that step, it has to be reasonable. And if there is a warrant, which, they did actually get a warrant here because Google required one, it has to have probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Well, they did describe the place and they described the time. They didn't know who the people were though. And also, because of how Google has its system, Google had to search 592 million people. So the answer to that is, well, that's Google doing the search. That's just how Google set it up. And the court rightfully says, look, I get it's not the government doing the search, but Google's only doing it because the government's making them. And so really it is a search of 592 million people, which is a general warrant. And we all know the reason why we have the Fourth Amendment is because of general warrants that the British had in colonial times, where you could search, the customs officials could search whoever they wanted to. And so we don't have general warrants in this country, so this is unconstitutional. That's basically it. They then say that the good faith exception applies because it's on its face. The warrant looked okay, and there's this test under this case called Leon we don't need to really get into. But essentially, that means that this warrant's going to stay in because of the good faith exception. So these three guys are out of luck. they're not the most sympathetic of defendants, of course. But going forward, no geofence warrants in the Fifth Circuit. Now, as I said, I don't know if this is, I mean, I don't know the technicalities that this is going to be that huge going forward because Google has really changed a lot of how it does its data. I think a lot of people still, though, will opt into this timeline data because it is kind of useful. Like, oh yeah, I've been here before. Oh, that's where the grocery store is in that neighborhood. And there's other services than Google. So this is a big case. The weird thing is, right, the government wouldn't appeal this. It would be the defendants. Now the defendants, they're going to probably want to litigate the good faith exception because it really matters to them. Otherwise, they're going to stay in jail. So I imagine they will try and push this case forward. I don't know what's going on with the Fourth Circuit case because that was at the step one, whether there's a search at all. That's probably going forward. So I imagine this issue is going to be going up, even though Google is changing how it's doing things.
Yeah, one thing I really liked about this case, Anthony, was Judge Ho's concurrence. And so even, as an IJ lawyer, someone who's pretty obsessed with constitutional rights and liberty more generally, when I read this case, like my overarching feeling was like, oh, this is not right. The government it's pretty creepy. The government shouldn't be able to get these geofence warrants. Um, but there still was this little voice inside me that was like, I'm kind of glad these bad guys are staying in jail. Like you said, this is a pretty serious crime,
Right.
and it's easy to see why people who are less obsessed with constitutional rights and liberty than perhaps we are might think like, I don't know, shouldn't the government have these tools to catch bad guys? And you can easily imagine the kinds of crimes that are even worse than this violent robbery, right? Where people would be like, murder or sexual assault or something where you're like, really, we should be able to have the
Yeah.
tools to catch these bad guys. And that's where I really, really appreciated Judge Ho's concurrence, where he says, I fully recognize that our panel decision today will inevitably hamper legitimate law enforcement interests. But hamstringing the government is the whole point of our Constitution. And he goes on to say, there are profound reasons why we value liberty. And I acknowledge that this is a balance, right, between individual rights and the rights to privacy and to be free from government intrusion into your life and the public safety or that ability of the government to kind of catch the bad guys. But there's a reason that our Constitution struck the balance it did, and we need to honor that. And ensure that we're not giving the government kind of free rein to just trample all over, our interests in privacy and being able to live our lives without the government checking in on us or having the ability to pinpoint exactly where we are at any time. So I really liked that concurrence from Judge Ho.
Yeah, that's a great point. And Judge Ho's bottom line really is if we really just wanted to catch bad guys, we wouldn't have a Fourth Amendment. And yet we have one. And so we have to interpret it. We have to engage with it. And if we're going to do that, there are going to be times where the bad guys get away. You can't have a rule where it only applies to people who haven't done anything wrong, because then the government's always going to win.
Right. And he puts it kind of, has a little pithy statement at the end of the concurrence where he says, our decision today is not costless, but our rights are priceless. Yes.
Yes,
Here, here.
exactly, exactly. So yeah, this is. I would imagine that either circuit may be taking this en banc soon. We will see. I'm sure this is going to come up in other circuits. I mean, this was just last 2 months, so very quickly. I'm kind of surprised we haven't had more of this at this point. So the Supreme Court, the little circle that we live in, has been very active in saying the Supreme Court has not taken a Fourth Amendment case in like 3 years now, which seems really weird. Every month that goes by and they wouldn't take another case, and the chatter continues. The long conference is just in a couple months. They're going to take up more cases. I don't see, and it seems like there might be a split. There's no like majority on the court right now for a certain view in the Fourth Amendment. Maybe that's why, but this dam's got to break soon, because we're having more and more of these big cases with some big splits. So I think next year might be the year, OT 24, where we get some more Fourth Amendment stuff. We'll see. Well, thank you, Kirby, for coming on Short Circuit today. Thanks to all of you for listening. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.